An Indiana father was sentenced to nearly a century in prison after committing an unthinkable act of cruelty, drowning his 3-month-old son in a bucket of laundry detergent and brutally attacking the baby's mother in a twisted act of revenge. The horrific crime and its shocking details, including the killer's chilling confession and the judge's blistering condemnation, reveal a tragedy almost too disturbing to comprehend. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is another Law&Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and the research is potentially linking ultra-processed foods to all this? Yeah, well, Morgan & Morgan, they're stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they're ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. This is, without a doubt, one of the most disturbing, cruel, heartbreaking cases, I don't even know other way to describe it, that we've ever covered here on Sidebar. You have a father's twisted act of revenge that ended in unimaginable tragedy, claiming the life of someone completely innocent and defenseless. A 3-month-old infant, tiny, helpless, barely beginning his life, was brutally taken by the very person who should have protected him, his own father. In August of 2024, authorities made a discovery that shook even the most seasoned of investigators: the lifeless body of this little baby. Jacob Moneus, submerged in a bucket filled with liquid laundry detergent. Yeah. What could drive a father to do something so horrific? What darkness led to such an unthinkable act? Well, here's the thing. That father now faces almost 100 years behind bars. But it's the haunting final words at trial, spoken both by the killer and the judge, that reveal the depth of this tragedy. The nearly year-long legal ordeal came to a close in Tippecanoe County Superior Court 2 in Indiana on July 1st, according to reporting from the Journal and Courier. Eliasard Moneus sat slouched at the defense table, his expression occasionally tightening in apparent pain. The outlet reports that it wasn't until the moment his sentence was handed down that he showed any real emotion, briefly wiping away tears. Let's get into the background real quick. So this tragedy unfolded on August 10, 2024, when police responded to a domestic violence call and quickly launched a statewide search for baby Jacob. And just hours earlier, Moneus had apparently attacked his wife, Edley Davaris, with a tire iron, leaving her with a fractured skull before leaving the scene, or I should say fleeing the scene. And as if that wasn't horrifying enough, soon came the chilling discovery that I mentioned before. Investigators found Jacob's tiny body sealed inside of a bucket of laundry detergent placed next to the kitchen trash. Now, before sentencing, prosecutor Elise Madigan addressed the court with devastating clarity, saying it doesn't really get worse than this. A father put his 3-month-old son face down in a bucket of laundry detergent, sealed the lid, left his son to die, and then went to the next room and viciously attacked the baby's mother. Jacob drowned in the bucket, swallowing 100 milliliters of detergent while he died. Now, prosecutors also revealed that Moneus had a chilling motive, and it wasn't just about anger, but it was about revenge. Prosecutor Madigan told the court, the defendant wanted to teach Edley and women a lesson. Can't disrespect a man. He said repeatedly he didn't care what the consequences were. He could not live without teaching Edley a lesson. And he didn't care if he spent the rest of his life in prison, which is exactly where he belongs. A lot to unpack here. First, I want to bring in special guest, Indiana criminal defense attorney Andrew Baldwin. Andrew, thanks so much for coming on. Good to see you. This is a really, really tough case. And I think from a defense attorney perspective, probably a tough case to defend. I mean, where do you even begin if you were representing somebody accused of a crime like this?
Probably the starting point would be an insanity defense. I don't know. It doesn't look like that was considered, but the depravity of the crime is as bad as I've seen it in 30 plus years. Honestly, as a defense lawyer, we sometimes forget. It's easy to forget the humanity of a situation. You're trying to defend your client. You're trying to figure out the best way to get the best outcome. and you have to really disassociate yourself from the facts. And that would have been a hard one to do on this case, to disassociate yourself from the horror of what really happened.
Yeah. And he is staring down a sentence of nearly 100 years. How is a sentence like that typically structured in Indiana? Are we talking like consecutive, concurrent terms? How do we get to 100?
Well, in this case, he was convicted of or pled guilty to attempted murder, which would be of his wife. He struck her with a tire iron, and she had to make the painstaking decision to leave her baby, the 3-month-old, at the home, while she drove to the hospital to get help for herself. And then he also pled guilty to the murder of the 3-month-old. And in Indiana, it's 45 to 65 years on murder, 20 to 40 on attempted murder. He was facing as much as 105 years. I was kind of surprised the judge gave him 92. He ran them consecutive. He didn't have to. The state put a memo together, and which is rare. You don't really see that very often. It's just orally argued what the aggravating circumstances and mitigating circumstances are. But the state took a little bit extra time to put a memo together saying, hey, this is so heinous that he deserves consecutive sentencings, one after another. And the judge gave that to him, totaling 92 years. I'm kind of surprised he didn't get the max. But he's going to be in there now for 75% of that time, whatever that math adds up to, the rest of his life.
You would think that there would be sentencing enhancements when you're dealing with a victim or who's a child or an infant, right?
Yeah, that is one of the aggravators in this case. In Indiana, it's a child, it's somebody under the 12 years of age or younger. If that's the victim, that is what we call in Indiana an aggravating circumstance that takes it at the higher end of the range. Also, along the same lines is somebody that has the care, custody, and control of a victim, in this case, the father. That also is an aggravating circumstance that tended to raise the sentence from the middle portion of it, where it could have been up to the higher end.
How much does a defendant's courtroom demeanor, like not showing emotion, affect the outcome of either a trial, right? If it does, if you're talking about somebody who goes to trial in front of a jury or judge, or sentencing. How much does it matter, the demeanor of a defendant, particularly given the charges?
I think in a trial, it matters in terms of where I'm always talking to my client about that. Jury's always watching you, and you have to work with what you have. Whoever your defendant is, you have to kind of work with what their personality is. And the judge is watching, of course, the whole way also. So if there is a conviction, the judge will factor that in at sentencing. They're not really, I don't know that they're really supposed to, because in individual human beings, we all react differently to different things. But it is a human nature thing. If you see a guy just, having no emotion about what he did to his child, it's going to have an impact on you, probably as a judge, to go at the higher end, and also just be very confused. I think a lot of judges that are, when you're my age, you have a lot of judge friends, and they talk to you about these things, and they're just like, this guy sat in my courtroom without emotion after what he had done, and it's crazy. And so I know for a fact that does affect judges, although they may not say it on the record.
How common is it for prosecutors, in your experience, to use that emotionally charged language, those narratives during sentencing? And from a defense perspective, how do you temper that down? I mean, what mitigating factors would you put down? What could you say? Who could you present?
I don't think it's that common. Most prosecutors, they trust the judge to do whatever the judge thinks is right. But on occasion, prosecutors, they're human beings also. And these types of cases can definitely impact their emotions as prosecutors, as human beings. And that's when you're going to see that type of language that you typically don't see in prosecutors. That's what happened in this case. As a defense lawyer, how do you combat that? You just have to kind of go with what you have. In this case, he had no prior criminal history. He did plead guilty. thereby not forcing a trial and the expense of a trial. And you kind of lean on those things as the defense lawyer to maybe get the judge's mind off of the emotion of it all.
We talked about revenge, right? So the seeds of Moneus' revenge on his wife appear to have been planted several days before this whole event unfolded, according to a probable cause affidavit that was obtained by Law&Crime. The conflict began on August 5th, 2024, between 29-year-old Eliasard Moneus and his wife, Edley Delvaris. And according to the affidavit, quote, Delvaris advised Moneus got upset with her on Monday, August 5th, 2024, and they have not spoken to each other since Monday evening. So then, at around noon on August 10th, 2024, officers responded to a hospital following a report of domestic violence. And the probable cause affidavit reads, quote, officers were advised the caller was Edley Delvaris, who reported being battered by her husband, Eliasard Moneus, and was driving herself to the hospital. Now, Delvaris told police in a violent altercation, Moneus ended up snatching little Jacob from her. The affidavit reads, she was at home sitting in a chair in her bedroom watching a church service with her 3-month-old son, victim 2, when Moneus entered the room and took victim 2. And roughly 30 minutes later, Delvaris said Moneus returned to the bedroom and began striking her repeatedly. The affidavit reads, Delvaris advised Moneus came into the bedroom where Delvaris was located and struck Delvaris with a tire iron or wrench multiple times. Moneus stopped striking Delvaris and left the residence in his vehicle. Delvaris did not know where victim 2 was at the time she was battered and did not see victim 2 in the residence after the battery. Delvaris' injuries were extensive. The affidavit notes that she suffered a skull fracture. Officers also observed multiple lacerations and a significant amount of blood on her head when she arrived at the hospital. And while she was being treated for severe injuries, including a skull fracture, police turned their attention to the couple's home. And the affidavit reads, officers searched Delvaris and Moneus' residence on Lexington Court, located blood spatter and other evidence of an altercation. But most importantly, there was still no sign of the couple's 3-month-old son, Jacob. Okay, let's stop there. So Andrew, based on the details on this, especially the timeline of the escalating violence, how critical is that, what was it, a 5-day gap in building a case for, let's say, premeditation?
I don't know that I saw premeditation there. I mean, another kind of avenue that the defense lawyer could have used, and I don't ever fault defense lawyers because they, especially in a case like this, they're in a very tough spot. But there was premeditation, I suppose, in the way that it's described. But it could also be argued that the guy just lost his mind at that moment in time, and then you could have gone for a voluntary manslaughter type of.
Even with the baby?
I would say, even especially with the baby. I mean, it didn't seem to me. It seemed to me to be at least arguable that this was the guy had been stewing, and then this is what happened. He made a rash decision at that moment in time. I don't know if there's that strong evidence that he was plotting. I don't know if there's emails or texts or commentary.
But doesn't premeditation form in an instant?
I don't. As a defense lawyer, I would argue no, it does not. I think when you're trying to when you're being accused or your client's being accused of premeditation, I would expect the jury need to see steps being taken along the way, because that's exactly what voluntary manslaughter is. It's kind of a snapping at the time. You do something rash that you hadn't planned on doing, and I didn't see the evidence necessarily of premeditation.
Wouldn't that be you need significant provocation, and what would the provocation be? It's not the classic example, right? They talk about you walk home, see your wife in bed with another man, you take out a gun in that heat of passion. What's happened here?
Well, like you said, I think it's just the defense lawyer in me. The way that I'm thinking is, this guy's sitting there stewing. That doesn't mean that he's the whole way that he's stewing that whole time. He's thinking, I'm going to try to kill my wife, and I'm going to kill this child. It could be that he just looks at his wife and he snaps. And, you're left with really bad options as a defense lawyer. I mean, you can go in and try to make that argument, and what jury, it would take a special talent to go into a courtroom and argue that wasn't premeditation. I understand what you're saying, Jesse, I do. And, but maybe at the same time, just the defense lawyer in me says, and maybe it was worth going to trial at least to see if you can get a voluntary manslaughter. It's not going to work. And those defense lawyers, knew a lot more about the case than I do, for sure.
So let's talk about what happened. After being unable to find Jacob, there was this statewide silver alert that was issued for the missing infant, and police pleaded with the public for help. The alert read, "The Lafayette Police Department is urgently asking the public's assistance in locating Jacob Moneus, a 3-month-old black male who has gone missing. Jacob Moneus is described as 1 foot 11 inches tall, weighing 13 pounds, with black hair and brown eyes. He was last seen wearing a blue shirt with a black bird on it and a diaper. Authorities believe that Jacob is in extreme danger and may require medical assistance. Due to the seriousness of the situation, a silver alert has been issued." Now, meanwhile, investigators, they were closing in on Moneus, and his vehicle was located at the Mason Garden apartment complex in Lawrence, Indiana, on the east side of Indianapolis, and officers from the Indianapolis Metropolitan Police Department moved in. They took him into custody, and when first questioned with the help of a translator, Moneus denied knowing where his son was. And Moneus reportedly doesn't speak English, only French Creole. And the affidavit reads, "Officers in Indianapolis attempted to question Moneus using a translator, but when asked about Victim 2's location, Moneus denied having knowledge of Victim 2's whereabouts." But later that day, during a more in-depth interview, he admitted to the assault on his wife. The affidavit reads, "Moneus admitted to hitting Devaris with a tool from his vehicle. Moneus admitted to hitting Devaris 2 or 3 times and hoped that Devaris was going to die from her injuries." And as for Jacob, Moneus confirmed only that the baby had been present in the home at the time of the attack, but said nothing more. The affidavit reads, "Moneus admitted Victim 2 was present at the apartment at the time the battery occurred, and Moneus did not leave the residence with Victim 2, but Moneus made no further admissions regarding Victim 2's status or whereabouts." And just after 4:50 a.m. the following morning, August 11, 2024, that is when the search ended in tragedy. During a second sweep of the Lexington Court residence, Lafayette detectives made a horrifying discovery in the kitchen. The affidavit reads, quote, "A young infant believed to be Victim 2 was located in an orange bucket with a snap seal lid. The orange bucket had the lid attached to the bucket and was located next to the trash can in the kitchen. A young male infant believed to be Victim 2 was located deceased in a dark-colored liquid inside of the orange bucket once the lid was removed." And shortly after, the silver alert was canceled. Lafayette police released the following heartbreaking statement. "Tragically, Jacob has been located deceased. He was found by Lafayette police officers earlier today after an extensive search effort. This is a devastating development, and our thoughts are with Jacob's family during this incredibly difficult time." And an autopsy would later confirm the unimaginable. The affidavit reads, "Dr. Harshbarger made a preliminary determination. The cause of death was asphyxia and the manner of death a homicide, pending toxicology results." So, Andrew, there's a lot of different things here, but you talk about the significance of the silver alert in terms of escalating the urgency and scope of a criminal investigation involving a missing child in Indiana. Is that something that's typically used and successful?
We get those from time to time, but not very often. I mean, maybe a few times a year, you're going to see something like that get on the television, or there'll be some type of an alert, but never do you see it end with this type of tragedy. I mean, that is very rare. It's usually like when a father that's not getting custody of his son goes to the house of where the child is and takes the child and is running it. That's the most common thing. And they're not going to kill their child. They're just trying to get visitation with their kid or whatever. But not in this case, it ended in absolute tragedy. Yeah.
What do you make of the implications of him initially denying knowledge of his son's whereabouts? And I wonder if that's maybe what led police back to the house to do a second sweep.
Yeah, I think that you're probably right on that, Jesse. They're just confused. Police were probably like, where in the heck is this kid? Could he have dropped him off at a family member's house? They're probably just praying and hoping that the child is somewhere safe. And or then, like you said, maybe they thought maybe just left the kid at the baby at the house, and that would be tragic as well, even if he just left him in a crib or something. And when I read the probable cause affidavit, I just wondered how easy it would have been for them not to lift the lid of that. It's even awful just to talk about, but that lid where the child was found. It would have been easy to kind of overlook that, because who would have ever imagined that a baby would be placed there or forced there by the father. And so thankfully they did do that.
It's unimaginable, unimaginable. And so this case reached a conclusion in July of 2025. According to the court document, Moneus was initially facing charges of murder, attempted murder, aggravated battery, criminal confinement resulting in serious bodily injury, domestic battery resulting in serious bodily injury, and domestic battery by means of a deadly weapon. But prosecutors, they ended up striking a plea agreement with him, where he pleaded guilty to the murder and attempted murder charges in exchange for having the other charges dropped. And on July 1st, Mr. Moneus stood before the Tippecanoe County Superior Court 2 to be sentenced. And the court handed down, as we've been talking about, a total of 92 years in prison. So 92 years of incarceration with the Indiana Department of Correction for 1 count of murder, 1 count of attempted murder, a level 1 felony. Take a listen.
On count 1, I'm going to impose a sentence of 92 years. Of 62 years. The maximum is 65, which is what's requested by the state in violation. However, I'm not going to accept the maximum by recognizing the fact that he has committed and pled guilty and accepted some responsibility. I'm imposing 30 years on count 2, the attempted murder, for a total sentence of 92 years. The counts are ordered to run consecutive. 92 years all executed at the Department of Corrections. By my calculations, we would have to serve about 67 years at the Department of Corrections. He's 29 years in now, so he'll be a very old man by the time he It seems just for these actions, for the horrible injuries he's imposed upon his wife, and the fact that he robbed his own son of a full.
Now, according to Journal and Courier, Moneus spoke briefly during the hearing, saying, "I'm living with remorse, with pain, stress that will never go away as long as I'm alive. I never thought I, Eliasard, could have been a prisoner for 1 day. My apology for what had happened." Now, the outlet reports he went on to lament his immigration to the United States, claiming he came in search of a better life, but instead found trouble and misfortune. His words were met with silence from the gallery, where Edley Devaris and her family sat. And then Judge Steve Mayer addressed the courtroom with a voice that was thick with emotion and fury, saying, "I think it's important to start out this day remembering little Jacob, a 3-month-old defenseless little baby whose mother described him as a bundle of joy. His entire life was taken away by the man who was his biological father. You killed your own child. I can't think of a worse crime. The thought of putting a 3-month-old upside down into a bucket of laundry detergent is unimaginable." And Meyer sentenced Moneus to 62 years for murder, 30 years for attempted murder, served consecutively. So with Indiana's 75% sentencing rule, Moneus has to serve, our understanding is, at least 69 years, meaning he'll be 97 years old before becoming eligible for release. Andrew, the chances that he's actually released at 97 for a crime like this, I mean, it's so far down the road, but what should we be thinking?
Yeah, I mean, his life is over. He's going to be in prison the rest of his life. There's no question about that. I think the judge did a smart thing there, by the way, of giving, and I said earlier, I was a little surprised that he didn't max him out, but it's actually smart for a judge to not max him out, because that just gives the appeals court an opportunity to reduce the sentence. It's an appealable issue. Max sentences are, there's case law that says it's for the worst of the worst. Although it is very arguable that this is the worst of the worst and deserved that max sentence, the judge still just gave him enough that he's never going to be able to get out.
And in the end, real quick, it seemed like an advantage for the prosecution. If we don't have to take this to trial and we don't have to subject a jury to this and go through the time and expense and the pain of this, and we can avoid it with a resolution where he's in prison essentially for the rest of his life, potentially for the rest of his life, it made sense that they negotiated this plea with him, right?
Well, I think so. I always appreciate prosecutors when you, as a defense lawyer, have a really bad case, bad facts, that a prosecutor says, "Hey, let's figure out a way to resolve this case. If there's just nothing that we can do, I mean, I'm a defense lawyer in my law firm. We're always trying to be creative and come up with ways to win, but there are just some cases like this one where you're not coming up with a way to win. And so let's at least have a resolution where as much as it can be said, everybody wins. The prosecution, taxpayers, the jurors that would have to watch those, see the photographs. I just can't even imagine how awful that is. And so I think that was a good outcome reached between everybody.
And one more thing before I let you go, I have to ask you about Moneus' brother, Isaac Moneus, because he wrote a letter to the court in defense of his brother, and he made some of the claims that he makes are pretty striking. I'm going to read a portion of the letter. He submitted this, I believe, on June 29, 2025. Here's what he wrote. Eliasard always went to church when he was growing up, and our parents instilled principle and moral in us to help us respect everyone and to do good in society. Eliasard was not used to drinking nor smoking. Our parents did not raise us that way. And he goes on to say he was never implicated in any form of wrongdoing. He is not violent nor arrogant. From the time he was little until today, he has never said anything that would bother me. This is why tears from my eyes won't stop. He is a very docile individual. He is not aggressive. We will not stop crying for Eliasard. What do you make of that?
I try to put the humanity of it affects everybody. And it's easy to just say, well, how can the brother not be crying for the child that died? And that would be an understandable perspective, but also he is a brother. And this is not the brother apparently that he saw growing up. His brother was a nice guy, and something snapped, something happened. And it's really hard for the brother to reconcile how this all happened. And so I think it'd be easy to get upset at the brother and say, what the heck are you talking about? That he's a docile guy? Come on, get real. I mean, who could do what this guy did? And you claim that he's docile. That doesn't make any sense. Well, he's his brother, and this we're human beings, and this is how, sometimes we kind of cope.
So though Moneus indicated he doesn't plan to appeal, he does have, I believe, 30 days to file a challenge. But for now, the case is closed, and this has left a grieving mother and a community and a family haunted by the cruelty that was inflicted on an innocent child. Andrew Baldwin, thanks so much for taking the time. Really appreciate it. Good seeing you.
Always good to see you, Jesse. Thank you.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.